Case number 121382. And could the court have the appearances of counsel, please?
Thank you, Your Honor. Matt Bretz on behalf of the appellant.
Good morning, Judge. Bill Townsley for Appellee. Thank you.
Very good. Thank you very much, counsel. Mr. Bretz, how much time would you like for a rebuttal? I'm sorry, why don't you turn on your mic there?
5 minutes, if I may.
All right, 5 minutes for a rebuttal. All right, you have 10 minutes. You may proceed.
Thank you, and may it please the court. I know the court is familiar with the briefing and the evidence in this matter, and so I'll only go into it very briefly. This case arises from a wreck that occurred when the driver of an SUV ran a red light at least 22 seconds after it had turned red. Didn't just barely miss the light, didn't go through on a yellow and it had it turn red, but went through at least 22 seconds after the light had been red, causing devastating catastrophic injuries to Jonathan Romain. This vehicle was owned by the defendant, the appellee, Mr. Shahouri, and ultimately a negligent entrustment claim was pursued. The district court granted summary judgment on that, finding that there was no evidence that the defendant knew or should have known that the driver was a habitually careless driver. And so we have two issues before the court today. The first one being whether the district court erred in granting summary judgment when there were controverted facts from which rational jurors could have found that the defendant knew or should have known that the driver to whom he entrusted the vehicle was habitually careless. And here there's ample evidence of that. As the court is aware, we hired a private investigator who followed the driver 6 times. In all but one of those times, the driver ran a stop sign or a stoplight or both. The 6th time, the private investigator lost the driver because the private investigator caught a red light. This is a driver who habitually is careless. Even passing a stopped school bus, letting out children with the stop arm extended. In this
Mr. Bretz, may I interrupt you for a moment on that point? Isn't one of the big issues, though, is the timing of that evidence, that the only evidence we have sort of pre-accident is the evidence, I think, is the driver had a speeding ticket or something like that, that all the evidence that you were able to get together, Mr. Bretz, from your investigators, all post-accident. And I know there was a lot of discussion about that in the district court. How does post-accident evidence show that Dr. Shahouri was aware of her habitually careless driving prior to the accident? I mean, isn't that the essence of a negligent entrustment claim, that Dr. Shahouri had to know about her habitually careless driving before he entrusted the vehicle to her?
Absolutely, Your Honor. That is the very issue in this case. And Dr. Shahouri, the defendant, has conceded that he knew her habits before the wreck, that her habits now are the same as they were before the wreck. And logically, if her habits now are the same as they were beforehand, and her habits now are habits of carelessness, then he knew that her habits of carelessness beforehand. It's the only logical conclusion that one can reach. They're the same before as they are now.
Well, can you really bootstrap, though, that post-accident evidence, impute that knowledge? How do you impute that knowledge to Dr. Shahouri if it all happened after? I mean, he testified, if I recall, that she didn't have habits of carelessness, and we only have one incident of a speeding ticket, and at least according to one case that our court decided, Barber versus Rhodes, they say, well, one incident of speeding isn't evidence of habitual carelessness. So in the face of his testimony, which is she wasn't habitually careless, and we have one speeding ticket, how do we bootstrap that back into prior to the accident?
His testimony that he wasn't aware of her habits of carelessness really is in question, given he also testified that he did not know that she ever speeded or sped, and we impeached that testimony with the fact that he even hired an attorney to get rid of a speeding ticket for this person. But he's conceded that he knew her habits beforehand, and her habits before and after are the same. And so logically, if he knew her habits before and they're the same as they are now, then logically he knew. And really, on summary judgment, the issue is whether there is any evidence from which a juror could conclude that he knew or should have known. And certainly his concession, coupled with the evidence of her habitual careless driving, are evidence. It should be noted that we don't have to prove on a negligent entrustment claim that she had had prior wrecks. There's a Kansas Supreme Court case on that issue. Just as a drunk driver may statistically drive 85 times drunk before the first time that drunk driver is arrested, doesn't mean that drunk driver isn't careless every time getting behind the wheel while drunk. That drunk driver is careless every time, even though somebody may not have been injured, even though that drunk driver may have gotten caught. But then it comes down to the second issue, where the district court excluded all of the evidence of habit and custom, even though the district court agreed that 60-450 does not mandate that habit evidence be from before the incident or before the wreck. The district court had added that requirement in and excluded the evidence, saying that 60-450 should be read to read that it's only prior habit evidence. And that's just not what the statute says. It can be testimony in the form of an opinion is admissible on the issue of habit or custom. Evidence of specific instances of behavior is admissible.
But isn't the question, Mr. Brett's, more than just habit? I mean, yes, I think you make a good argument that it's admissible for habit evidence, but you also have the question of what did Dr. Shahouri know prior to the accident? And he said, this evidence that you're seeking to get admitted is all post-accident.
It is all post-accident evidence, but he's conceded that he knew her habits before. He's conceded that he had ridden with her before. He conceded that he'd observed her before. And her habit is every time she gets behind the wheel, she runs stoplights, stop signs, she nearly hits curbs, she goes over the center line, she drives 10 or more miles over the speed limit. Perhaps one of the most careless drivers that one can imagine, somebody who constantly does these things. And the defendant has conceded that he knew her habits before. He refuses to concede that that he had seen these things, but he's conceded at a minimum that he knew her habits before. And under 60-450, evidence of specific instances of behavior is admissible to prove that habit that he concedes he knew about.
Mr. Bretz, how do we distinguish this case from the Barber v. Rhodes case? I assume you're familiar with that case. I know it was cited in Mr. Townsley's brief, but it's an unpublished case from 1990 where a panel of our court, under similar facts, it involved a car wreck where the plaintiff was trying to collect damages from the driver's employer. And there was an argument about this driver's driving history, and the district court excluded the defendant's driving record, and it was upheld on appeal. And the Court of Appeals said, well, evidence of the driver's driving history in this case, it was post-hiring, is what they were focused on, is irrelevant to show what the employer knew at the time they hired the driver to drive their vehicle. How do we distinguish that holding in that case from what we have here?
In that case, the employer did not make the concession that the defendant, appellee, made in this case. In that case, the employer did not concede that they knew the driver's habits and customs before the wreck. Here, the defendant concedes that he knew the driver's habits and customs. He disputes what they were, but he concedes that he knew them.
Okay.
And just as he refused to admit that he knew that she had sped in the past, his testimony, as the court is aware, is somewhat in question. But he's conceded that he knew it.
Okay, thank you.
And for summary judgment, it's the facts, or the legal standard is whether there is just any evidence from which a jury could conclude. And here there certainly is.
All right. Mr. Brutch, you've used your 10 minutes. If you want to keep proceeding, you can, but you'll be eating into your rebuttal time.
No, thank you, Your Honor.
All right, thank you. Mr. Townsley, you have 15 minutes. Mr. Townsley, why don't you turn on your microphone there, please? I forget that all the time, too.
Let me start again, and thank you, Judge. With volume this time, may it please the court. I represent Dr. Shahouri. We're here to ask the court to affirm the district court's granting of summary judgment below. In this case, the plaintiff has produced no evidence whatsoever that the driver, Genwa McKimick, who is the wife of Dr. Shahouri, was incompetent as it pertains to age, experience, physical or mental condition. Plaintiff has produced no evidence to support that she was habitually reckless or careless on May 19th, 2017. Insignificantly, and the key, and this is what you just touched on, Judge Powell, that the plaintiff has produced no evidence whatsoever that Dr. Shahouri had any knowledge at all that his wife was incompetent or habitually reckless as a driver on May 19th or before in 2017. The case here is fairly straightforward. There are two issues that are raised on appeal that I think are easily resolved. With respect to the evidence question of KSA 60-450, the ruling of the court was that the affidavit of the private investigator was inadmissible. On review in this court, that's an abuse of discretion standard, and there's no evidence here to suggest that there was any abuse by the judge in reaching that decision. And the factors that were significant for the district court judge were that the affidavit of the private investigator involved times driving 6 to 9 months after the accident. She was in a different vehicle. In the 6 or 7 occasions, there's an issue of whether that had a sufficiency of number of incidents, whether that would even matter if we consider post-incident as well to be important or significant for what happened on May 19th. Again, I don't think we get to those issues. The decision of the district court was supported by the evidence in the record and supported by the law. So then we get to the issues for negligent entrustment. And again, for negligent entrustment, we have 4 elements that we have: the entrustment of a chattel to someone who was incompetent, and that the entrustor knew of the incompetence of the entrustee, and then there was negligence to follow, causing an injury. So we're dealing with elements 2 and 3, but element 3 is what really spins this case. It's what's Dr. Shahouri know. What did he know on May 19th? And there's just simply no evidence. The evidence for Genwa McKimick was she was not intoxicated. She hadn't been involved in any prior accidents in 12 years of driving. Her license had never been suspended or revoked. Again, she'd have 12 years of experience. Mr. Bretz talks about his impeachment of Dr. Shahouri, but yet Dr. Shahouri admitted in his affidavit for summary judgment months before his deposition, he knew about that ticket, that one ticket 2 years earlier. And as you've suggested, Your Honor, there is ample case law in Kansas that one ticket doesn't create a habit or a custom that would require an entrustor to be concerned about the individual. In fact, our cases support that somebody can have a prior DUI, but yet that still doesn't raise the bar to the point where you have to be concerned. The issue here is that Mr. Brett says that Dr. Shahouri admitted he knew. And what he admitted is he knew that his wife was a good driver. He said he followed her for 300 miles from Texas on one occasion. He's seen her drive around town. He's ridden with her on a number of occasions. His most precious items in the world are his children, which he drives to school every day. She drives their friends' kids to school every day. He talks to his friends. No one has ever said anything to him about any negative aspect of her driving prior to May 19th of 2017. The argument of Mr. Bretz is fallacious in that he uses this, what he considers the transitive property in math and formal logic, that if A plus B and B plus C you've got A equals C. Where it all falls apart, though, is Dr. Shahouri says, I have no knowledge of my wife being a negligent driver. And more significantly, there's no evidence produced by plaintiff or appellant in this case that that's accurate. The allegations in appellant's briefs are that she was likely talking on the phone at the time of the accident. In fact, the evidence showed that she was not. He says in page 11 of his brief, she may have been in other accidents, but we don't know. Again, there's no evidence of that. And he finally says, Dr. Shahouri must be lying with this self-serving affidavit. Again, there's no evidence to support that either. This is one of those cases where, if you have good facts, you pound those facts. If you have good law, you pound the law. What if you don't have either? You pound the table. And I hear Mr. Brett's pounding the table. Again, the affidavit of the private investigator, even if admitted, wouldn't have impacted what Dr. Shahouri knew on May 19th. But the fact is, the judge did deem it inadmissible. And on appeal, there's nothing to suggest that there's any reason that wasn't an appropriate decision by the district court judge. So
Mr.
unless you have
Townsend, can I interrupt you for a moment on this issue of admissibility and sort of drill down a little bit about that? Do you agree with Mr. Bretz that it might be admissible as habit evidence, the post-accident driving habits of the driver in this case, but the district court ruled it inadmissible on relevance because of whether it goes to the issue of what Dr. Shahouri knew? Do you agree with that analysis, or do you disagree?
And that's a question to me, Judge.
Yes.
Well, I absolutely agree that evidence is not relevant or admissible. Again, this is all we've seen, and is an affidavit that was produced in a punitive damages motion in the prior case. That's the affidavit that's at issue here. There's never been any testimony by the private investigator. There's nothing to support his allegations other than what's set forth. Again, I
guess I want to get educated a little bit about. Mr. Bretz has made a number of points about habit evidence, and my thinking in looking at this is that habit evidence, both before and after an accident, can be admissible as habit evidence, but the problem with Mr. Bretz's attempt to get this evidence in has to do with the elements of negligent entrustment, and that with entrustment, it all focuses in on what the owner, the entruster of the vehicle knew on or before the accident. And that's where it creates a relevancy problem. Is that how you see it?
Well, and I think, as we said in our brief, that even if all that was admissible, exactly what you said, Judge, it doesn't go to what Dr. Shahouri knew on May 19th. It's not helpful to the court at all to determine what Dr. Shahouri knew on May 19th, 2017, if it's something that happened 7 months later. So I believe that the court properly determined that it was not relevant and that it was inadmissible. But again, even if it came in, it doesn't deal with the significant and the primary issue we have here. That's element number 3. What does Dr. Shahouri know as of May 19th, 2017? And in that regard, the facts are undisputed and uncontroverted that he had no knowledge that his wife was an incompetent driver as defined in the state of Kansas.
Thank you, counsel.
And Judge, I really don't have any further argument to make. I'm surely would welcome any further questions, but otherwise, we simply ask that you affirm the granting of summary judgment from the district court.
All right. Seeing any questions from my colleagues? Doesn't appear so. So thank you, Mr. Townsley. Mr. Bretz, you have 5 minutes.
Thank you, Your Honor. The defense skips over part of the definition or part of the element of negligent entrustment. It's not just what the defendant knew, but it's also what the defendant should have known. And I'm quoting from the Gregg versus Wichita State University Kansas Supreme Court decision, and it's knows or has reason to know. And here, the defendant certainly had reason to know of the driver's, his wife's driving habits. He concedes that he knew her habits, but he certainly had reason to know, even if he wants to deny that he had actually seen her do the things that she constantly does.
Mr. Bretz, I hear your argument. What I don't understand about it is, and I'm trying to think of a similar example in my mind. Let's say, that you have a husband and a wife, and the wife, one time in the past 10 years has smoked a cigarette. Okay. And then she's smoking a cigarette for some reason and then it comes to, I don't know, something legal happens about it. And then over the next 6 months, a private investigator starts watching her and she smokes a cigarette, 6 times. Number one, I have a question about whether that's a habit, because a habit is essentially a mechanical course of action. So I don't know, whether that's sufficient to be a mechanical course of action. But the fact that she has done that 6 or 7 times in a 6-month period after this critical period, how does that, and then you ask the husband, were you familiar with her habits before this juncture in time? Well, I knew she had smoked a cigarette in the 5 or 10 years before. So I was familiar, with her habits or whatever, I was familiar with the fact that she was a non-smoker for 10 years. So that's how I kind of see your argument. So maybe she turned into a smoker after. I just don't see the relevancy of something that happened afterwards, how that goes to what he would have known before. And you could do the same thing with her being a cheater, that maybe she was cheating on him, and he wouldn't have known. So that's what I get. It said, yeah, I'm familiar with the fact that she was faithful to me, of her habits, that she came home every night and she was faithful to me. And then afterwards, you've got a private investigator showing that 5 times she was unfaithful afterwards. So that's my only issue. I'm not really getting the logic.
Thank you, Your Honor. And I think the difference in the evidence in this case versus your example is that in this case, the defendant and his wife have testified that her habits now are the same as they were before. There's no testimony that her habits have changed. And so there's no testimony that she smokes now and she only smoked once before. The testimony in this case is that her habits now are the exact same as they were before.
Well, when that testimony came out in the deposition, first of all, was it asked in the context of what the private investigator saw?
I could not answer that without going back to the transcript, Your Honor.
Okay.
The other thing, but two other things. One is this is not an abuse of discretion standard. This is a de novo issue on the admissibility of habit evidence under 60-450 because it is the issue of statutory construction is a de novo standard. And then the last thing, defense counsel.
Mr. Bretz, wait a minute. Let me stop you on that point. Isn't the issue though not about whether it's admissible as habit evidence? I mean, I think you're probably right. It's admissible as habit evidence. The problem is relevancy because of it goes to the issue of what Dr. Shahouri knew on or before the day he entrusted the vehicle to the driver.
Knew or should have known.
Right.
Right. And with his concession that her habits are the same now as they were before.
But we don't know the context of what he said that.
Just in the context of her driving habits, which is the issue under negligent entrustment, is whether she is a, quote, habitually careless driver.
Well, what Mr. Townsley said was that he said that in the context of, you know, here's what I know. I know that my kids are the most important part of my life. And I think she's a good enough driver that she drives them. I drove behind her for 4 hours, on the way back from Dallas. She was, or Texas or whatever. I mean, he's saying it in the context of, yes, her habits haven't changed at all. She's a great driver.
And that testimony is impeached by the surveillance video of her driving through the parking lot at the school with the kids, walking through the parking lot while she's on her phone, driving and running the stop sign in the school parking lot.
But that's not impeached as to what he knew when he entrusted her with the car.
Other than through his own testimony that he was familiar with her habits.
Right.
I
guess it all depends on, we'll look at the deposition.
Mr. Bretz, did you make any arguments
on the deposition? I'm sorry.
I'm sorry, go ahead.
No, I'm done.
Did you make any arguments to the district court about this evidence being admissible as impeachment evidence?
We did, Your Honor, yes. It was pointed out in our brief. It was discussed during oral argument, and it's set forth in the brief here. And it's not just what he concedes that he knew, it's what he should have known. I think I'm out of time, but I would be happy to answer any other questions.
You are out of time. Thank you, Mr. Bretz. Any more questions from the panel? Seeing none.
No.
Seeing none. Thank you, counsel, both very much. We appreciate your time, and we will take this matter under advisement, and we'll get you a written opinion as soon as we can.
Thank you.